Welcome. This is IP rules for test prep and tutoring companies. I'm Kevin Organichek. I am the founder of the Association of Test Preparation Admissions and Private Tutoring, formerly a researcher on learning styles and executive functioning. I was an exec at Kaplan for a long time and have been in the world of tutoring and test prep business for about 20 years now. Formerly a high school science teacher, still love science, and was an admissions advisor at Ohio State. I have a couple of kids, two of them have been through college, and I have more than a couple, I have several kids. Two have been through college and two are approaching that period of time. And I love to talk about the test prep and tutoring business. I think tutoring and supplemental education in general is important. I don't think it has to be reserved for the privileged. I think everyone should have access to it. And I'm super pleased to help local companies who have really superior products, in my opinion, to benefit from my knowledge and to benefit from Mr. Kaufman's knowledge. So Mark engages in copyright, trademark, and contract law, among other things. Co-founded the firm Kaufman & Kahn LLP. Can be reached at Kaufman at kaufmankahn.com. And the website is www.kaufmankahn. And there'll be a more visible way to connect with Mark through his slides. So one quick thing, disclaimer. So Mark, Mr. Kaufman is not providing legal advice, and the listener viewer should consult with an attorney to discuss how the law in their jurisdiction might apply to their particular facts and circumstances. So we're really pleased to have you, Mark. Thank you for making time. I know how busy you are, and so it's terrific that you could actually make time here. So let me set you up as the presenter, and you should be able to take it away.
Okay, I can see you in large, and I can see me and a few people up there. So great. And I'm just admitting someone else. I guess I'll be admitting the people. I hope they're all your members. So it's great to be here. I provided some advice to other tutoring companies, and my background is in copyright law and trademark law. I do business contracts and I do lawsuits. I like to think that the lawsuits are an opportunity to make an agreement, sometimes under forced circumstances, and that a contract needs to be drafted in a way that if it were ever litigated, that the judge would understand it, and that hopefully what you wanted to get would prevail. So everything's got to be drafted with that unfortunate possibility at the end of it. Good contracts you draft and you put in a drawer and never talk about it again because everyone gets along famously. But if they don't, it's nice to have something you can enforce.
That's terrific. So the format here, folks, is that I'm going to go through and ask Mark general questions based on feedback that I received last week, and then we'll go into a short Q&A. And if you have questions, you are welcome to ask them then. In the meantime, if you want to put questions in the chat, that would be helpful as well, so we can try and get to everything by the end of the presentation. So, Mark, let's start with some softballs. So, can you tell the group the definition of things like brand, trademark, licensing, like?
Well, okay. So your brand is what you're presenting to the world. Is your image. Part of it's going to be your trademark. Part of it's going to be how you're known. Branding is really more of a marketing concept than a legal one. But part of that marketing concept is having rights that you can enforce and protect. So your trademark is if you can register a trademark, then you can be the only one using that name or only one using that slogan. And in the U.S., trademark rights are based on your use, not your first use and continuous use, not the first to go to the trademark office. So,
interesting.
So I'm not sure, Princeton Review is a solid trademark. That is, I'm sure, is registered. And if someone else were to use that name or a confusingly similar name, I'm sure the owner of that trademark would come after them, particularly if it was in a similar field.
Okay, terrific. How about licensing? So there's a lot of licensing going on, or there has been for, since sort of the advent of the internet and digital content. So what exactly is licensing, or how has it changed?
Well, that's a huge. I mean, that's a huge question. But uh, licensing is the permission of the owner of rights, say in a copyright. I mean, I'm getting questions. I'm admitting it to anyone who asks. Um, Anyone who owns content, who may or may not have registered the content, hopefully they have registered the copyright in the content, has a bundle of rights. And among those rights is the right to let other people use it, whether it's a photograph or music or text or test questions or test answers. And each of these things someone can be given written permission, um, can receive written permission to use this content. And it's very important that to the extent something is protectable by copyright, if you fail to abide by the terms of a license, you're not just breaching a contract, you're infringing on copyright, because that the concept is the owner of the content has um, um, entire rights, and if you infringe them by going outside of the bounds of your license or using something longer, you can be in trouble.
Gotcha. Okay. And then, so this is not maybe so relevant here, but it may be for a couple of folks, a patent, like what?
A patent is I don't do patent law. Patent is the protection of an idea. Copyright protects only the expression of an idea, and patent does an idea itself. I'm looking for some widget. Here's a watch. Okay, the means of perhaps the means of this watch working inside it, the battery, the mechanism, is probably protected at some point by a patent. Patents cost at least $5,000-$10,000 to start, can be much more depending on the complexity of it. And what it does is it buys you a right to go and sue people for 17 years. After 17 years, it expires and becomes publicly available.
Gotcha. Okay. So before I move on to the next area, does anyone have any questions pertaining to the things that we just covered?
Okay, I'm seeing questions coming up in the chat. Can you see the chat as well? It's just me.
I do see the chat.
Okay.
And so Jan is asking about,
are they part of the public domain? I had a feeling that was going to be a prime question.
I was hoping we'd cover a few more things before we dove into this.
Hey, before we get to the real juice. I mean,
so Jan, we will add. That's a great question, and
the quick answer is no. Okay.
The answer we have is no. And before we delve more deeply into that,
right,
that subject, let's talk about how tutoring and test prep companies can protect their content. So it's sort of regrettable, but there's the history of test prep and tutoring is littered with disgruntled former employees sort of leaving and taking content or claiming content that they created while under the employment of a company is theirs, and sometimes taking clients. I mean, it's not all that sorted, but there are those instances out there. So, so for the folks on this call who own the companies that are providing these services, what are some things that you would suggest they do to protect their own intellectual property?
Okay, to the extent that assuming that the people that work for you are employees, let's start there, because a lot of them may be treated as independent contractors, which is its own potential issue. But let's assume that they're employees and then move from there. To the extent that your employees create something that is protectable by copyright, they automatically, if it's in the course of their work is work made for hire and it belongs to the employer. So that's relatively straightforward, particularly if their job description is to create content like original questions, to get if everyone can mute. I'm not I'm an IP guy, not an IT guy, and I'm not sure how to mute people. So if everyone can take the time to mute, that's great. um Rob Williams, someday I'll meet you, and but you're taking the screen. Okay. um anyway, so the if they're employees doing their work, then that's that. If they're not employees, or you're not sure if they're employees, but are in fact independent contractors, or you want them to be treated as independent contractors, how do I do this? Then you need an agreement with them, because copyright is not assignable unless it is in writing. Um,
I'm going to reclaim the host and mute
that
everyone.
sounds fine. Okay. I don't have a lot to I'm unmuted. Very good.
Excellent.
Thank you.
Cool.
Okay. So assuming that the tutors or whoever else is working or making content that's protectable by copyright are independent contractors, you need to have an agreement with them in which they, some people call it a work made for hire agreement, but what it really, work made for hire is very limited in scope under the copyright statute. So you want to have an agreement that says this is a work made for hire, but in case it's not, because it's probably not, the owner, the tutor, whoever is creating original content, is assigning all the rights to the company, so that it belongs entirely. So that the company owns it, and you need that in writing, and it needs to be expressed that that there's an assignment of rights, of copyrights, and anything less than that can be deemed to be inadequate. The third thing is in between. It's more of a labor law question as to whether this person's really an independent contractor, which companies often like to do so that they're not responsible for paying for the employees' taxes and health insurance and whatnot. And that can be playing with fire with your state's or city's labor department. Because if that person goes and seeks unemployment, the labor department is going to inquire, did you control? It's a degree of control and supervision. If the tutor is truly independent and is setting up their hours as they wish with your clients at whatever time they want, with their own equipment and their own vehicle, then perhaps they are independent contractors. And if they have their own company, so that it's Joe LLC, and Joe LLC's employees Joe, that's even better. But you want to, you can be if you're controlling when they show up and they're using your equipment to do their work, you may very well be their employer, even if it's less than 20 hours a week. So, but that's a labor law question, which I've only picked up when people have been audited by the New York City Labor Department.
So to recap, if you're an employee, then so if you're a tutor and you're an employee of a company, then basically what you produce is work for hire for that company.
Sure. Of course, it might also be preemptively wise in order to avoid conflicts with your departing tutors, to make that express, to make it clear that everything that you do for the company is work made for hire, we own it. B, we have confidential and proprietary information, like our list of clients. You cannot take that. And, C, maybe you shall not solicit any of our clients, any of the people that you met through us. Those are our clients. If you don't have that in writing, they can go ahead and take everyone in sight after they leave. And then D, but much more problematic, is a non-compete. And that's hard to do. No court really wants to stop someone from making a living in their field.
Right.
That's probably more difficult to enforce against tutors. Thou shalt not tutor for 2 years is a stretch. But you shall not use my materials. Anything you do to contribute materials are mine, and all your students are mine. That's enforceable, and that needs to be in writing
Very good.
and ahead of time. One last thing, ahead of time, not as they're leaving. It's not enforceable when they're leaving because you're not giving them any consideration. As they're signing up, you're giving them a job. That's consideration for the restrictions you're putting on them.
Okay.
That's why it needs to be ahead of time.
So in either case, then, just articulating it at the front end of whatever, whether it's an employment agreement or a contract.
Independent contractor, yeah.
Great.
It makes sense to have in writing.
Really helpful to know. And I've seen a lot of agreements, and they're not all, forward facing like that. So that's excellent information. We do have a question
From Neil.
Well, what if an employee copies someone else's question? So I presume that is like someone copies a College Board question on the SAT, and Neil, you can expand on this. Are you on the hook as a company for that employee use of that copyrighted material?
I mean, potentially yes, in a lot of ways. First of all, there's the concept. Here's some Latin. Respondeat superior, okay, that the employer is responsible for the actions of his employee, A. B, if that copying is being used in the furtherance of the business's commercial profit, well, then, of course, you've profited directly or indirectly from either your employee or your independent contractor. So, another thing that you want to add to that agreement is that anything that your employer's independent contractor contributes is going to be, they warrant and represent its original, and they have the right to do it. So that
I'm going to guess that we all have tutors who are going into session and they've got their own satchel full of drills they got from here, a couple of passages they got from there. They've got a whole file full of stuff they're pulling in for any given kid. If they don't have the rights to that, presumably the business is potentially liable for that. How big a transgression is that, or is it something that would rarely come up?
Well, I think it comes down to, my wife's a theater director, and she mostly directs the middle school and high school plays in our town. She'll put up music, say, how did you ever get the rights for this Bruce Springsteen music as a scene change? Of course she didn't. But to some extent is how far below the radar is it? Is it if it's literally in someone's satchel and they're showing it to a kid and it's not publicly out there, then it's hard for the company that might own that to know about it. But if it's being published or distributed or copied en masse, then it may very well come back to bite.
Let me, if I could interject here. So I was told, and in fact, used to oversee the process by which the tutors would use materials from like a particular book, but we as a company had purchased the book. So we had theoretically purchased the license of at least that book so they can use the material.
You purchased one book. You got one.
No, for every student. So every student has like a student kit, right? And the kit includes whatever, let's say Barron's SAT stuff or the SAT, the official SAT guide. So I was told that, you could use that material. That doesn't mean you could copy it en masse and,
you can copy it at all. I mean, theoretically, you can't copy it at all.
Right.
I'm sorry, I interrupted you.
Material to tutor the student because you had purchased it and you had licensed it, essentially.
Well, you didn't license it. I mean, in that instance, there's a difference between license and you purchased it. You can do whatever you please with it. There's the first use doctrine. You can take, I don't have any books around me. Behind me, I might have books. You can take a book and do anything you want with that book. You can give it to someone else. You could burn it. You can leave it on your shelf and never look at it again. You can do what you want, but you can't copy it. So if each student has their own book, they can go ahead and the tutor can work with it. Does that answer your question? I feel like you were asking a trickier question that I've misunderstood.
No, I think I probably just wasn't using the right verbiage.
Although along those lines, I was talking to an owner yesterday, and he would buy something like the Blue Book, or the current edition, he was doing academic tutoring. Let's say it was a textbook. Because it was remote, they were copying and emailing PDFs of that textbook. But he said, but I bought the textbook every time to make sure I was covered, but it was coming through snail mail, and so it wouldn't get there until weeks later. And I was thinking that may not protect him.
No, I don't think it does. The bundle of rights of a copyright is the right to copy, distribute, publish, license, make derivative works. And the derivative works part is what's going to happen to the extent people are making their own questions based on the standardized tests. Those are the rights of the copyright owner. So even making a PDF for the very legitimate purpose of teaching someone is theoretically is breaching copyright law. Whether the owner of that textbook is going to find out because one copy has traveled by email to one student is unlikely. If it was posted on the website, so it's easy for all the tutors, clients to take and enjoy, you've just increased exponentially the likelihood of being caught for it is an infringement, but it's also more likely to be caught. As someone told me years ago to relate, I am not your rabbi, I'm your lawyer. So I'm not telling you what's right to do. I'm telling you what may happen if you're caught.
Gotcha. No, those are good questions. Okay. So let's get into it now. So the use of College Board practice tests, which exist on the College Board website, the use of previously released ACT tests as practice tests for test prep and tutoring companies.
Free meeting will end in 10 minutes.
I thought I had this on the
We're gonna have to talk very fast.
on my other account here. So we better dig in. Talk to us about the use of those materials. Is it allowed if you don't charge for your practice?
No, I mean, skipping straight to it. Right as soon as you asked me to be doing this, I went and downloaded the fine print, as it were, on College Board and Princeton Review and Kaplan. And when you look, you have to look for legal or look for copyright and trademark notices. And in there, among the second or third paragraph, they all say, there's no need to request written permission. This is, I'm just going to quote from College Board. If you only intend to print or copy an online article or excerpt from a College Board publication to be used in an educational and non-commercial setting, each of you are commercial. They expressly allow students to download the work so they can learn how to take the test. But you're downloading it and disseminating it is a commercial use. And in between there, you can have your students download it and then talk to them about what they've learned and what they've done. But the reissue is back to those basic rights: copying, publishing, distributing, those questions and answers. There's copyright in the answers, is infringement. And that is more likely to be chased by the big companies that own that content.
So is that to say that it matters who owns the printer that this thing comes off of? If it comes off your student's printer, you're fine. If it comes off your printer, you're not fine.
I would say that's right. Because your printer would be part of distributing it for commercial purposes to the student. Their printers, they're learning to take the test, and that's allowable. And they're not commercial. They're not going to make money. They're going to spend money. Right.
What about if it comes off the school's copier or printer?
The school, it may the school may be infringing. They may be sitting behind that educational purpose, and to some extent that may very well be legitimate, particularly in connection with students who don't have access to printers or even internet and all that. divide among in our society of people who have access to information and those who don't. But I believe that's the schools. I would say that's still infringing because each of the kids, unless there's an issue that it's not accessible, each kid should be buying the book that has that test in it, and photocopying it to spread it around. It's infringing. You can certainly justify it on the basis of not everyone can afford this, but that's not for you to decide. That's the right of the copyright owner.
So we had a question about ACT has stopped publishing retired ACT tests for practice by students. Does that make old versions of the test available to be copied, or can they be copied because they're no longer being produced and printed by ACT?
No, I'm afraid not. There's a lawsuit I just blogged about. Well, Hallmark went and destroyed a bunch of their cards, or they sent their cards out for destruction, and then someone else took them, bought them, and resold them. Well, it's old stuff. Apparently you didn't want it. Yes, but it still belongs to Hallmark, and those old tests still belong to the creators of the ACT questions. The books themselves, if you can find them, of course, back to the first sale doctrine, whoever has the book can go ahead and continue using it at their peril if they're outdated. But the copying of them for practice purposes isn't allowed.
Gotcha. Okay. Any other questions on this, on using ACT or College Board material?
Are you asking me or someone else?
No, I'm sorry. I'm asking everyone. And okay, so here's a question that has something to do with what you and I discussed the other day called mirrored writing. When developing our own materials, how far from the original question, design and makeup, do we have to go to be safe legally? So we talked about how people would write SAT questions by taking questions from the College Board and changing the numbers, but keeping the question stems the same. So this is to that in that
right.
way.
So the test for copyright infringement is whether you copied. Now, unless there is a smoking gun saying, take this question and change it, which to some extent is what you're suggesting here, that I gave instructions to my employees to take the same question and change it a few ways so that it might not be recognizable. That smoking gun is going to override any changes you made, because what you're doing is making a derivative work. There's this urban myth that if I change it 5%, 10%, 30%, that's enough. There is no enough. It is every case is individual, and what it really comes down to is, if there's no smoking gun of demonstrating how that work was created, the question is whether it's substantially similar, and so that's going to be a litmus test. Is virtually the exact same question where you've just changed the numbers. We were talking about math, the word problems in a math test. Johnny is running towards Jane at 30 miles an hour, and Jane's running at 10. When would they bump into each other? Now, if it is that kind of simple, that there's very few other ways to express it, that is not protectable by copyright, because there's limited ways of talking about that kind of mathematical forces. But short of that, and I imagine most things are more complicated, it's not safe to take someone else's questions, copy them, and try changing them. And there's lawsuits out there where that's happened.
Great.
Now I'm saying that we have 3 minutes
can I just copyright
left.
Algebra and be done with it?
That's a trademark. And no, you can't. Been there, done that, right? That's generic. So anyway.
So Carol asks, if you buy one single book, can you use it repeatedly with multiple students over time under the first use doctrine?
Yes. Yep. Yes, you can. It's going to be awfully dog-eared. Try not to mark up the margins. But yes. What shall we do in 2 minutes when this ends?
So why don't we do this? So just quickly, testimonials are popular now. Can you just briefly tell folks what they should have to protect themselves when
Yeah,
they testimonials of people?
they should really get an agreement in writing from the people contributing it. If you like this, please sign this paragraph saying you have my permission to use my words up there. Something that gives, because there's copyright in the testimonial and people may change their mind. And it's really unlikely that someone who says something glowing about your tutoring service is going to come back, but maybe the second kid didn't do as well in the SATs. And so you want to take down that testimonial, you know.
Makes sense. Always, yeah, always be careful and use caution at the front end. Why don't we, if you want to share your contact information, I know you have lots of sort of boilerplate agreements and things that will help, could potentially make life easier.
Can you see, there's my contact information?
Yeah.
Okay, great. So that's where I am. I am actually, today is my first day virtually in the last 6 months that I am in my New York City office, having become vaccinated. So I am, but as it says there, the most dependable way is my cell phone number. And you can find us on the website, on our website. It has you know, our emails, and you can contact us. It'd be great to help out anyone who's got a question. Let me know if I can help. Standardized contracts may really be a good thing for you to have with your employees, at least to stop them from taking your tutoring clients. And you know, if you can avoid disgruntling your employees, I suggest gruntling them instead.
That's excellent. All right, everyone. So if you have additional questions, you can shoot them to me in email.